Welcome to the CodeCast podcast. Real-world insights for your daily medical coding and billing processes. And now, here's your host, Terry Fletcher.
Hello, everyone, and welcome to the 225th episode of the CodeCast podcast. My name is Terry Fletcher. I hope everyone survived the weekend wherever you are. I know that we all had some interesting weather. Those of you on the East Coast, I hope you're safe with all the snow that got dumped on you. I know on the West Coast, and most of you know I went to visit my daughter in Arizona, we had the worst winds I've ever seen, and it was definitely bumpy driving over there and just dealing with anybody who has allergies. You know how that feels. So, and we're all worried every time we sneeze. We're thinking, oh my gosh, COVID, but it's allergies, it's dust, it's wind. So make sure that you're not too afraid of that. But if you are, make sure you, take advantage of those free testing kits if you are concerned. So let's get into our topic today. So I wanted to visit the No Surprise Act because there's a lot of confusion on what is actually your role in that. And because the No Surprise Act is actually poorly written, in my opinion, it's difficult to understand these regulations. And I mean, even Stark is easier to understand. And a lot of the guidance out here is misleading, if not just wrong. So I'm going to give you kind of the short explanation of what you need to know, because there's some key factors in the No Surprise Medical Bills Act, and that's kind of the long title of it, and what you can and can't do, and who it applies to, and also some of the hidden definitions under the NSA that you may not know. Also, there is a free webinar this month if you would like to participate in that. It's February 16th. It's through the NSCHBC, and you can sign up for that through their nschbc.org, and it is on the No Surprise Act. So I'm going to give you kind of a head start into that, and then hopefully you sign up for that and get some good materials. It is not CEU offered, only because it is free. So just make sure you're aware of that. But you know what? It's a good free offering by the society that I belong to for National Association of Certified Healthcare Business Consultants. Okay, so let's just take a look at it for, first of all, what it is. Everyone needs to know what balanced billing means, because that's kind of the crux of the No Surprise Act, where they say you can't balance bill a patient. The problem is everyone thinks that means you can't bill a patient. Well, that's not what it is, and we want to be very clear on what that means. There is a definition of it on healthcare.gov, which also is monitored by Medicare and the federal government. So you always want to take a look at that if you ever need an answer or a coverage explanation for Medicare or anything like that. So balanced billing means that when a provider bills a patient, they can't bill them for the difference between the provider's charge, so your actual charge, and the allowed amount. So for example, if the provider's charge is $100, the policy allowed $70, the provider can bill you for $30, but they may not balance bill you for covered services. So what that means is that they can't balance bill the difference. So if they're billing you any amount at all, it's deductible and copay. So if they are a preferred provider with the plan, they can't bill you between the difference between what they billed and what the plan allowed. They can only bill you what your share of cost is, or what I should say, what the patient's share of cost is, and that is typically tied to a deductible or a copay. This doesn't apply to federal government because they have their own rules on how you bill a patient, and so always keep that in mind as well. Who this applies to, and this is really important because I think people forget this. So first of all, does the No Surprise Act, and for short the NSA acronym, does it apply to clinics? Well, parts of it do. So this is one of the more complex areas, and many sources mistakenly state the rules do not apply to clinics. Well, at first we didn't think it did, but it does. So kind of think of the act as having three prongs. One prong deals with emergency services. One deals with patients who are getting care at a hospital or an ASC, so an ambulatory surgery center. It also applies to freestanding emergency departments and air ambulances. And then the final prong or tier deals with estimates for patients who are not using insurance to pay for their care, either because they're uninsured or because they're choosing not to use their insurance. So that third prong that applies to services, or I should say applies to clinics, clinics will have to give still good faith estimates, is what they call it, to patients who are not using insurance to pay for their care. It doesn't matter if they are under an insurance plan, because you know what their out-of-pocket's going to be, and it's clearly stated on the EOB that you would get from a preferred provider plan. But the first two prongs will apply in clinics to the extent that clinic physicians are providing services to clinic patients at either a hospital or a facility or an ASC. But for the most part, the first prongs do not apply at the clinic level. But if you send your patient to a hospital or ASC, you will need to post a one-page notice somewhere in your clinic and provide a copy of that notice to the patient that's being sent to the hospital or ASC. And that's that good faith estimate of what they can expect to get as far as their out of pocket. That's not balance billing, because they are responsible for a certain share of cost. Now, again, does No Surprise Act apply to ASCs? Yes. Oh my gosh, yes. The obligations on ambulatory surgery centers are exactly the same as they are for hospitals. So the only good news is that if the physicians at the ASC all participate in the same insurance plans that the ASC participates in, so if you're a part owner to it, then your impact is a lot less. So then good faith estimate requirements basically are for the patients that need to get it for facility and for the for that particular stay. So the thing is making sure that anytime you send a patient to a facility, you basically have to let them know what their out-of-pocket is, and so does the facility. Let's hope it matches. So what is a disclosure notice? Okay, and I don't like what CMS named them, so they should have named them, a different form number, because there's several documents that CMS has, and using the same form number 10780 for different forms is not helpful. So a disclosure is a one-page document that gives patients an explanation of their rights under the No Surprise Act. So CMS has a draft form you can use, but you don't have to use that exact form. It just has to be a version of that form to include what they have on there. The form must be posted and made available in person, electronically, or via mail based on what how the patient wants it. This is very patient and payer friendly, so I'm just putting that out there just so you know it's not physician friendly. But the good news is at this moment, there's no penalty for failure to do this, but I'm sure civil monetary penalties, if it's reported, will be issued later this year. So this is where you still have to do it. Now, what is the good faith estimate? Okay, so as of January 1st, 2022, if a patient is not using insurance to pay for their care, they're entitled to what they call a GFE. That's a good faith estimate of what their care will cost. For any service, schedule 3 or more business days in advance. And then there's a long list of things that good faith estimate must include. So not just telling them that what the cost will be. So it has to include things, which I'm not sure why, but it has to include details like diagnosis and procedure codes, and even the physician's NPI number. I couldn't believe that when I saw that. This applies to every scheduled service, including office visits, if it's more than 3 days out. When the event is scheduled between 3 and 9 days out, you must provide an estimate within 1 day after scheduling takes place. So if it's scheduled 10 or more days out, you get 3 business days to provide the estimate. And again, what if you don't provide the estimate? Well, in the absence of an estimate, or if the estimate understates the actual charge by $400 or more, the patient now can file for the dispute resolution procedure. In addition, it's getting nuts. In addition, when the civil monetary penalties are issued in the future, it's possible there could be fines as well for not having that GFE. So you've probably heard of notice and consent. Okay, so when a patient goes to an in-network facility but receives cares from physicians who are out of network, a lot of physicians are on call, and they're not necessarily part of that patient's network. And so there are limits on the liability the ability of the out-of-network physician to balance bill the patients. Usually patients choose their insurance, typically employer funded or supported, and they can choose, a cheaper insurance now because of this balance bill situation. So, for example, if you are an anesthesiologist or radiologist or hospitalist, they can't balance bill even if the patient's out of network. This presents a problem. This is going to force those types of providers who are on rotation or on call for emergency patients to get on these networks. Otherwise, they're going to be out of luck with some of the reimbursement. There are also limits on balance billing for a certain service, like assistance at surgery and laboratory and imaging. But for surgeons, it is possible to balance bill if, now here's the big ifs, if the services are not emergency services. So with emergency having the same definition under the EMTALA, or 2, the patient consents using government drafted notice and consent. I don't see why a patient would consent. That is just crazy. Why would you? I wouldn't. And so talk about, patient friendly. And the other thing that concerns me about this is why would they do this to emergency services when some patients are coming in and there's really not, late at night or at a time that isn't during 8 to 5 business hours. And the patients, there's not somebody running around to the patient saying, please sign this before they roll them into the OR, before they, do an emergent x-ray or something to that effect. So this is where it gets really, dicey when it comes to what this is. And then the other thing that you have to realize when it comes to the No Surprise Billing Act or the NSA is what your physicians now have to do when it comes to making sure that they are updated with the plans for their address, their phone number, and their how many physicians are in the group, and who is actually in network and who's out of network. That's a really big deal because if you don't do that, they can drop you without any kind of notice from their plan. And I know that there's a lot of doctors trying to get in. And so you have to really be careful of that, because if they just say, you know what, you didn't have this updated, you have to have it updated within 60 days when there's a change or when you get a new patient or anything like that, this is where it's going to be a problem, because your administrative staff is going to have to step up their administrative work to make sure that everything is current. Because the reason a lot of this came about is that patients that were getting emergency services, which I thought this was only applying to that when this first came out, it's been updated since we've changed government administrations. And now they apply it to almost everything, emergency and non-emergency care. But the reason that this came out was mainly because of ambulance care, because of emergent care. Patients were coming in and basically didn't have a choice because of their location. They were having an episode of emergent care, of urgency, and then it was paid maybe 40 to 50% because it's out of network, and the patients were getting, $30,000, $40,000 bills. Well, that I get. I mean, patients should be protected from something that's, they don't have a choice on. But this is now letting patients have a choice on lowering not only what they purchase for their health plans, or lowering how much share they're going to have to pay their premiums with their employer sponsored, and then also be able to not have to pay an out-of-pocket if they don't feel like paying, or if they want to pay cash and not go through their insurance, and now they get the lower rate. I don't understand why that's okay. And it's not a surprise if you're going in knowing it, but under the law it is. So a couple other things into the final rule. So ban surprise billing for emergency services. Now again, know what that balance billing means. It means that you're billing the difference between what you bill and what's left. It's not the patient's cost sharing. So if the patient has coinsurance or a deductible, that can be billed to that patient, but it has to be based on in-network provider rates. So it can't be higher than if such services were provided by an in-network doctor. So that's a really big deal. I feel bad for the physicians that are on rotation, like an assistant surgeon or an anesthesiologist, because they're almost always out of network, because they're on rotation. And so they can't balance bill, again, what was billed versus what was paid. It has to be based on an in-network amount. And that's where it becomes an issue. So let's say that you're trying to get an average amount of what you're going to bill the patient once this is done, you're going to have some kind of a median plan. I would look at Blue Cross Blue Shield and basically just see what they're paying for certain things and kind of keep that as your standard. And hopefully that will go through, because you're going to have to also hope that the payer pays you something against your services that are not in network, because now the payers have a choice. They can either pay you or they can say you have 45 days to negotiate, which is just, I'm just going to say it, it's just stupid. So why would a doctor want to do anything emergent anymore? This is just, it might be, on one hand, they're saying it's safeguarding patients. This is going to hurt patients because physicians aren't going to take call. And so this is where it's going to backfire. I can see this going to backfire, and this is going to definitely be a problem. I sent in 2 letters to, Secretary Becerra, HHS Secretary, and just said, I see what you're saying as far as no patient should forego care because of fear of surprise billing. But what if they show up in the ER with no doctors available because the doctors are in fear of not getting paid and having to pay for arbitration? You've got a problem here. So to me, it should just be on emergency services, not on all services that take place in a facility. And that's where it's going to be a challenge. But make sure that you sign up for the NSCHBC free webinar that will be later this month that I mentioned, nschbc.org, and see what you think. And just make sure you take notes. It's going to have some good information. And then also, I wanted to make sure that you were aware our Telehealth Summit, which will have 6 CEUs through AAPC, is on the 24th and 5th of February. We have a great lineup. I'll be doing 2 sessions. We've got Sean Weiss, we've got Sonal Patel, we've got Christine Hall, Eric Rubenstein, who's also retired agent with the OIG, and we have 2 healthcare attorneys, Amanda Weish and Brianna Santoli. We also have David Zetter, who's a colleague of mine. So just really look at that again on the NSCHBC website, and hopefully you will register for that, and we'll see you. It's 2 days total, and we're going to have, including Q&A, 9 sessions. So it'll be quite impactful for you. So we hope that you join us for that. Okay, so just wanted to give you a little bit of a personal tidbit. So all the wedding plans are secure. We're good. And it looks like we are a go for now 41 days until our wedding. So until my daughter's wedding. So we're excited about that. The only thing left is we have to get on a Zoom call with the DJ for the playlist. So that'll be fun. But anyway, that was a pretty fun. While I was recording today, I happened to have on the Pro Bowl for the NFL. Is anybody watching that? Oh my gosh, what a mess. I could have played in that. Talk about touch football. I've played in flag football teams that were harder than that. They were basically not even touching each other. It was awful. So I hate games that aren't competition. It was just terrible. But anyway, hope you all have a great rest of your week and make it a great day. And thank you for listening to the CodeCast podcast.
For more information on medical coding, billing, auditing, and compliance, including how to hire Terry, follow Terry on Twitter @TerryCoder1 or visit her website at www.terryfletcher.net. Podcast producer Joe Kuzma. Music producer Dassassin Music.